You must admit, there's a little childish feel to the idea that us as a big independent nation out here, standing on our own 2 feet, must go to Great Britain to solve the squabbles that we have. If we have arguments that we cannot resolve in our own judicial system, in our own courts, then the ultimate place, the ultimate authority that we must go to is in England in the Privy Council, and we go to Daddy, and Daddy will say who is right in this situation, and Daddy will tell us what to do. It does have a kind of feel like that. Although I do understand some of the arguments as per trust, etc., and the long-standing nature of that institution, the Privy Council, there would be a lot more trust in a lot of their rulings, especially even on the global standard too. So I understand that, but I also get the feeling like, how can you truly be independent if you're going to them to ask them how? But nonetheless, that is the present situation that we are in. And currently, we have a case before the Privy Council that is, to some extent, arguing about the very nature of our constitution, the very nature of our judicial system, the ideas underpinning it. There's a statement that says, well, not a statement, a formulation that goes, it's better that 10 guilty people go free than one innocent person be punished or wrongfully punished. And someone added on top of that, it's better that 100 guilty people go free than one innocent person is punished. I believe that was one of the American founding fathers that made that difference on it. And that statement is a bit at the base of the Western judicial system, the English judicial system that we have coming down to us right now. And there's some Christian origin in it, but the idea is the current idea we have about justice in our country. And that is kind of where some of the argument is currently with the case that we are seeing before the Privy Council that was already decided in our appeal court here in Trinidad and Tobago. Now, before we get into that, make sure you hit the like button. You are subscribed, hopefully. If you are not subscribed, make sure you subscribe. Share the video to someone who you think would like this kind of content. Hey, this is interesting. Find out about the legal situation and changes in and around Trinidad and Tobago. So yes, share the video by all means to people who may like that. Drop a comment, tell me what you think along the course of the video, and let's get into it. Now, there's a beautiful summary from the Privy Council of this case as it currently stands, and when I read this summary, I say these people are pretty proficient. The summary is very concise. I like it. The summary is very concise. It covers what the facts of the case. It covers it so quick and briefly and concisely. I like it. I appreciate it. So on this ground, okay, Privy Council, we see you. Attorney General of Trinidad and Tobago versus Achille Charles, number 2. Jurisdiction Court of Appeal of the Republic of Trinidad and Tobago. The case summary. The issue is, the central issue is whether Section 5.1 of the Bail Act 1994 is inconsistent with the Constitution and therefore susceptible to being struck down. Facts. So this is just a brief summary of the facts up to this point. Mr. Charles and 5 others were charged on the 5th of December 2010 for the murder of a man and kept in custody on remand from that date pending trial. Mr. Charles' preliminary inquiry commenced on the 16th of January 2012. So he was already under arrest and in custody for 2 years before the chief magistrate and was halted on the 3rd of April 2017. So that's from 2010 to 2017 already. His case is still in court. When the chief magistrate was elevated to the High Court, the acting chief magistrate decided that the preliminary inquiry should be heard de novo, new. The new preliminary inquiry was discharged on the 21st of May 2019, now 9 years, on a no-case submission, and Mr. Charles was released from custody 9 years after first being detained. So they threw out the preliminary inquiry on a no case submission. They said we have no case. Well, the prosecution has no case. We throw out this. So 9 years, 9 years of your life you spend in jail awaiting a magistrate to throw out the case saying, well, there's no real case here. Can you imagine that? 9 years in jail for what the judicial system determines is no case. That does not seem right, does it? On the 6th of February 2020, Mr. Charles brought a constitutional motion for a declaration that Section 5(1) of the Bail Act, which provides that bail cannot be granted in cases of murder and certain other offenses, is unconstitutional. The act has been passed under Section 13 of the Constitution. The judge dismissed the motion, holding that Section 5(1) of the Bail Act was saved from challenge as an existing law by Section 6 of the Constitution because it reenacted the position in force when the Constitution came into effect in 1976. So, okay, this is a bit of unique law in Trinidad and Tobago, and I believe in Barbados also, where we have a savings law. And that was done during the period of independence because we didn't want the laws from before the period of independence to clash with the new constitution that we just wrote. So the law, there was a piece in the constitution, the savings law, that says anything that was law before the constitution cannot be struck down because it was already law before there. Let's not tamper with that. So if it's a saved law, if it was from before the point of the constitution, then it would still, the constitution cannot strike it down basically. And that's the argument that's part of the argument they are saying. The Court of Appeal allowed Mr. Charles' appeal, holding that Section 5(1) of the Bail Act was unconstitutional because, and this is important, there are three reasons here. One, it derogated from the fundamental rights and freedoms in Section 4 and 5 of the Constitution. So that's the first reason. We're just going through this is a brief summary of it to then see where we are at right now and some of the arguments that are being put forward in the Privy Council right now against this. So it's just briefly going through for some of us who may not be up to date with it. So the first part is that it derogated from the fundamental rights and freedoms in sections 4 and 5 of the Constitution. Of our Constitution. And what are those rights? Just head over to the Constitution. It is hereby recognized and declared that in Trinidad and Tobago they have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex the following fundamental human rights and freedoms, namely the right of the individual to life, liberty, security of the person, and enjoyment of property, and right not to be deprived thereof except by due process of the law. So the very first A in Section 4 of the rights enshrined, it kind of takes away from that. You're taking away someone's right to security of the person, etc. And then further down than that, they give a whole list of other rights. And then Section 5, except as is otherwise expressly provided in this chapter, and in Section 54, no law may abrogate, abridge, or infringe or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms herein before recognized and declared, without prejudice to subsection 1 and some more legal language. Parliament may not authorize or effect the arbitrary detention, imprisonment, or exile of any person. So what they went through here are a series of things that Parliament, in its duties, yes, they can write laws, but there are limitations on the laws that they can write. So Parliament cannot authorize or effect the arbitrary detention, imprisonment, or exile of any person. That's A. You go down now to F and you see Parliament cannot deprive a person charged with a criminal offense of the right to be presumed innocent until proved guilty according to law, some more legal language, and 2, to a fair and public hearing by an independent and impartial tribunal, or to reasonable bail without just cause. So if you cannot give them that to a fair and public hearing by an independent and impartial tribunal, there's an or, and the Parliament cannot deprive a person charged with a criminal offense of that right to a reasonable bail without just cause. That's in Section 5 of our Constitution. And that is what is being alleged is unconstitutional about the Bail Act, the bail bill that was passed. You cannot take away someone's right to bail because it is in our Constitution. So for Parliament to take away someone's right is literally unconstitutional. That's what is being alleged. Number 2, So that's the first part. The first part of the problem that our appeal court had with it was the section 4 and 5. The second part was it was an existing law, and therefore it was not an existing law, sorry, and therefore it was not saved under section 6 of the Constitution. So the appeal court is saying that actually no, it was not an existing law. It wasn't here before our Constitution was there. That's not true, so it cannot be saved. And 3, it was not protected by virtue of being passed under section 13 because the derogation was not shown to be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. So that quote is very important because they talk about section 13 of our Constitution, and I'm going to section 13 of our Constitution. I think these things are actually kind of important. So section 13 of our Constitution says acts inconsistent with section 4 and 5. So these are acts that can be passed, that would be allowed, although they may be inconsistent with the list of rights and freedoms, etc., that we have been granted by the Constitution in section 4 and 5. So this is how we get those acts, section 13, the exceptions. An act to which this section applies may expressly declare that it shall have effect even though inconsistent with sections 4 and 5. And if any such act does so declare, it shall have effect accordingly unless the act is shown, and this is where the importance comes in, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. So that's why that little quote is very important. That quote comes from our Constitution, and our Constitution says, yes, you can have exceptions, you can make acts, the Parliament can make acts that are inconsistent with the rights and freedoms. You can infringe on those. But they have listed the other two stipulations. You must have the majority, etc., etc. So you need that special majority. That's why you hear about the special majority so regularly in Parliament to enact acts that contravene our Constitution. You must have the special majority. But even if you get the special majority and you enact an act, if the act is seen to be not reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual, then the act can be struck down. And that is what our appeal court was saying. Our appeal court was saying that although they did have the 3/5 majority needed to enact this act that was against the Constitution, it was not reasonably justifiable. And I think this might be the biggest point here, because it seems obvious it contravenes the section 4 and 5, but if it is in line with the exceptions here, then it can pass. So that is the present stage we are at right now in the Privy Council. Those are the arguments before the Privy Council. And we're going to get briefly into one article that came out recently that gave a brief glimpse into the arguments that the government is putting forward and that they are being rebuffed with at the same time. So we're getting into that. Privy Council told Parliament did not trust judiciary on bail. That's quite an argument. The Privy Council has been urged not to be swayed by a claim there was a measure of mistrust by the Parliament of the judiciary when it passed legislation in 1994 to introduce a prohibition to bail for anyone charged with murder. The startling submission was made by the state's lead counsel, Peter Knox, Queen's Counsel, in an appeal of a landmark ruling of the Court of Appeal in February that Section 5(1) of the Bail Act of 1994, which prohibited bail for people charged with murder, was unconstitutional. In his submissions before a panel of 5 Privy Council judges on the first day of a 2-day hearing on Wednesday, Knox said the Parliament could override powers and freedoms provided for under the Constitution. And when it enacted the 1994 Bail Act, it did so because of concern with the rising crime situation in Trinidad and Tobago. So the argument started off, he's saying that yes, the Parliament can override those freedoms given in the Constitution, and it's true. In our Constitution it is said that the Parliament can override them. The Parliament can override them by Section 13. All right. As he pointed to several Hansard records, Knox said it was important to look at Parliament's rationale in enacting the 1994 law to introduce the prohibition to bail for murder. He said at the time Parliament was concerned about the serious rise in crime, and when the act was passed, no one raised an alarm that it put a ban on those charged with murder applying for bail, because it, granting bail on a murder charge, had never been done before. Knox said the law was introduced to curb crime and disorder and maintain the common position as it related to offences that carried the death penalty. Now, this is where I am very confused in this entire thing. They say here, the lawyer here is saying that this law was enacted to curb crime. But at the same time, he is saying that what the law proposed doing, refusing bail to the murder accused, was already being done. So why enact a law for something that was already being done? And if it was already being done, how is it going to curb crime now that you enact a law to do it? I do not get that. How does that work? You said no one was granted bail for murder either way. So you're going to make a law now to make sure no one can be granted bail for murder. And that's going to stop murder? How? How does that figure? I don't understand that. It's probably just above my level of understanding. Bail was not being granted because it was thought it can't be, and no one saw any problem with that at all. That is because of the high crime rate. The public has the power to decide which laws are passed. He also suggested that at the time, the thinking of the Parliament was that it did not trust the courts, because at the time, people on bail were committing crimes causing serious concerns. Parliament is saying, I don't trust you, the court, and I'm taking some of your jurisdiction away. Here you had a crime problem where people on bail were committing crimes. Before the Bail Act, there may have been a window of opportunity to grant bail, but it was never done. I do not understand this argument. I do not understand this argument. He is saying that they didn't trust the courts because the courts were granting bail and the people on bail were committing crimes. But if we're talking about murder, because this is specifically about murder, not the other crimes, about murder. So specifically, you didn't trust the courts because they were granting bail, and the people on bail were committing crimes. But at the same time, you're saying no one was granting bail for murder. So how could they be granting bail for murder and not granting any, and no one was granting bail for murder at the same time? Those two things can't both be true at the same time. So if no one in the court was granting bail for murder either way, as you say, then what didn't you trust about the courts? Why take that jurisdiction away from the courts? How could you not trust the courts if they were doing the very same thing that you wrote a law for them to do? It just does not make sense to me. If someone of you in the comments understand that, please tell me in the comments, how does that make sense to you? Because it really does not add up to me. In his opening remarks resisting the state's appeal, former Attorney General Ananram Logan, senior counsel, that's very interesting just by the way, said it was startling to hear the state's submission that the law prohibiting bail was born out of mistrust of the Parliament for its own judiciary. I take umbrage. The fact there may be a public concern with the way the courts decide cases is not only unique to Trinidad and Tobago. Ram Logan maintained the courts were not a populist institution. He said to equate public concern with a proposition, there was mistrust of the legislative arm to the judicial arm to justify an encroachment on the court's jurisdiction was alarming. So what he is saying there is the court isn't about populist concern. The court isn't about popular opinion. Justice isn't what most people think justice should be. That's not the system of justice we have. Justice doesn't go according to vote. And really and truly, you don't want that. That's mob justice. And mob justice gets very scary. So the judicial system is not supposed to be under the sway necessarily of populist concern. So saying that there was popular concern for some of the cases does not justify taking that to mean that you mistrust the judiciary. For you to say that there was a lack of trust in the justice system, then you have to see what the reason for that was, besides just the public having concern. The public having concern cannot equal lack of trust in the judiciary. And then to take public concern to then translate that to mean taking power away from the judiciary does not make sense. And according to the former Attorney General, he sees that as alarming. And I can understand what he's saying there. Where does one draw the line? Today it is bail for murder, tomorrow it might be something else. And the point he's saying there is, if you just take public opinion on changing laws pertaining to the judiciary, then where does that stop? The public opinion could determine everything as it comes to justice, and that's not exactly what we want. Earlier, Knox, in defending the enactment of the Act, said it was not enough to say Section 5 was unreasonably unjustifiable in a society that had proper respect for the rights and freedoms of the individual, and we know why that little quote there is very important, as the appeal court held in the ruling of Achille Charles, a former murder accused who got tried, right? But that little bit there, unreasonably unjustifiable in a society that had proper respect for the rights and freedoms of the individual. With respect to the case of Achille Charles that we read the summary of, spending 9 years in jail for what the courts eventually decide was no case. So no case, 9 years in jail. I think there's no doubt when looking at that is unreasonably unjustifiable in a society that has proper respect for the rights and freedoms of the individual. That would have been that man spending 9 years in jail for a no case charge. So I could understand why the government's lawyer wants, let's not look at that. That's not the fair thing. Let's not just look at that. He is saying, Knox said, the question had to be determined by the law lords was if the law was capable of justification, he maintained it was. So let's not say whether it was unjustifiable specifically in that case. Let's say whether it is capable of justification. I don't really understand that differentiation, but I guess we'll see if the law lords in England fully understand that differentiation, because to me, if it's unjustifiable in one specific case, remember what they speak about for the rights and freedoms of the individual. So if it's not justifiable in one case, then it is not justifiable. How can you say it's capable of justification if we know for a fact that there's one case where it is unjustifiable? And therein we go back to the formulation I said at the very beginning, where the theory behind our justice system is it's better that 10, 100, how much ever, guilty people go free than you prosecute and harm that one innocent person. So if we know now for a fact that one innocent person, well, in one case here, let's not ascribe innocence because we don't know that necessarily, but one case here, a person was unjustifiably held for 9 years. You cannot justify holding someone for 9 years on no case. So that is unjustifiable. If we have one case of that, isn't it then unjustifiable on a whole? I would propose it is, but then again, I am not the government. I am not the government's lawyer, and neither am I the Privy Council law lords. Knox conceded that prior to the 1976 Constitution, although there was a discretion for the court to grant bail for murder, it was never done. However, he said the discretion did not apply to those accused who had already been committed to trial. So this already throws out part of their case with the saving law, where they proposed that it was a saved law, because he is kind of already saying that before the Constitution there was already discretion for granting bail for murder. So how is it a saved law if there was discretion for doing it? You could say it was never done, but that isn't to say it could not have been done. So I am not sure about that saved law bit. All right. Thank you for tuning in. That's all I have for now. Drop a comment, tell me what you think. I found this was interesting, the whole legal dive into it. Tell me if you were piqued by this also, if this was interesting and entertaining to you, or if this bored you, and who cares about the legal ramifications of the laws in Trinidad and Tobago. That has nothing to do with anyone. Either way, I hope you're educated, informed, or entertained. Make sure you hit that like button, drop a comment, make sure you are subscribed. You can hit the notification bell also, that does help because you know whenever a new video drops. And I will see you later.